She is actively involved in various networks and has represented Malaysia as a delegate in regional conferences hosted by the Thailand Institute of Justice, Young Southeast Asian Leaders Initiative, and the Dragon Foundation in Hong Kong. Jaiju secured her LLB honours degree from the University of London and was admitted as an advocate and solicitor of the High Court of Malaya. She is now practicing in Messrs. Zain and Company, a member of Dentons. Her portfolios include real estate, banking, and finance, as well as corporate and commercial advice. Next, we have CS Devarshi Gupta, who is a practicing company secretary, trademark agent, entrepreneur, and a startup enthusiast. He has the experience of working in the legal services industry, especially providing his services in business formation, intellectual property rights registration and litigation, IPO management, mergers and acquisitions, and private equity. Mr. Gupta has a BA LLB degree focused in corporate law. He frequently writes blogs or articles on topics such as corporate laws, tax laws, and new trends in the legal and finance aspects of our economy. Next, we have CA Pramila Kar, who is a practicing chartered accountant since 2017, hailing from the Delhi chapter of NIRC of ICA. She has a bachelor's in commerce from Delhi University and is currently practicing as an independent CA at Pramila Kharb and Associates since the last 5 years. Next, we have CS Anushka Damani, who is a law graduate and an associate member of the esteemed Institute of Company Secretaries of India, ICSI. She is a practicing company secretary and also acts as a regular guest faculty at the Hubli chapter of Eastern Regional Council, ICSI. Anushka is passionate about corporate law and secretarial compliances. Next, we have CA Hemant Gupta, who is a fellow member of ICI and a practicing chartered accountant, who is a graduate from Deen Dayal Upadhyay College, Delhi University, in BCom Honors. He did his articleship during CA course from Deepak Nagpal and Company and became a chartered accountant in the very first attempt. He also holds a law degree from Law Center 2, Delhi University, in addition to being an insolvency professional as well. He is now a senior partner in MS Rao and Emma Chartered Accountants, which is a 43-year-old CA firm with 28 partners and 22 locations across pan-India and proudly among the top 100 CA firms in India. He has a diverse experience of 18 years post-qualification spread across various sectors and industries, including audits of public sector banks. He specializes in the field of audit, taxation, financial risk structuring, debt solution, and currently focusing on insolvency laws. Last but not the least, we have C. Raunak Agarwal, who is a chartered accountant working at PwC, PricewaterhouseCoopers, one of the big four consulting firms in 2017. She has worked previously at Vision CA as a mentor to various chartered accountant students and aspirants. Raunak is passionate about teaching, mentoring, and coaching youngsters for the cause of educational empowerment. Now, I would like to request Advocate Riddhi Bhanushali from the Mumbai High Court to take over the conference. I hope I'm audible, Riddhi.
Yeah, Shravan, you're audible. Greetings everyone, I'm Advocate Riddhi Bhanushali and I'm back for presenting another amazing session to all of you. I request to all the attendees switch on their webcams for the conference. I hope everyone has switched on their cameras. Now, I would like to invite Miss G. June, a practicing advocate and solicitor at High Court of Malaya, Malaysia, to commence her speech.
Thank you very much, Shravan and Riddhi. Vanakkam and good evening. Thank you. Good evening, everyone. Thank you so much for having me. So I would like to share my slides. So let me just share my screen here. So can you see my screen now?
Yeah, ma'am.
Can you see my slides?
Yeah, ma'am.
Okay. So we can see the full slides here, yeah? Hi, can you see the full screen here?
Yes, ma'am.
Yes,
Okay.
ma'am.
Okay, cool. All right. Thank you very much. So, it's my honor today to share some of the financial compliances for startups. So, I will be sharing the compliances, the rules and regulations purely from a Malaysian law perspective. Yeah. So, just before we go on to the compliance, so I hope that all of you have the chance to visit Malaysia, to visit the capital city of Malaysia, which is Kuala Lumpur. So, why would foreign investor want to invest in startups in Malaysia? So, a few of our core strengths are we are a multiracial, multicultural, and a multilingual population. So, our we have three main races in Malaysia. We have Malay and Chinese and also Indians ourselves. So which is why following from that, we are multilingual. We can speak Mandarin, we can speak Tamil, and then we can speak, of course, the Malay language and also a few of our dialects as well. And of course, we have a strong middle class in Kuala Lumpur, and also we have a high internet penetration. So this is very convenient for those who are looking to a tech startup or an e-commerce startup. And further to that, we also have a relatively low labor cost, yet we have a highly skilled talent pools. So our government is in support of startups. So what we do is they introduce these fast track visas. Also, they have a very good support system. We will go to that later on. All right. So just want to introduce to all of you. We have 4 Malaysian startups being listed on the Forbes Asia 100 to watch list. So they are the Brio HR, Dr. Onco, Droppy, and also iHandle Energy Solutions. Yeah, they are across, as you can see, they are different. They are of different categories: education, biotech, e-commerce, and also construction and engineering. So what are the common type of business vehicles in Malaysia? So I think, it's similar to India. Oh, I want to do a startup. You cannot just, publish your services or publish your goods to the world at large. No, you have to register yourself first. So how do you do that? So in Malaysia, the 3 most common types are, number 1, sole proprietorship, or in short, we call it a sole prop. So it is, as the title suggests, it is a one-man show, right? So meaning that, you are the one doing the marketing, you are the one doing the sales, procurement, you are the one doing everything. Of course, there are pros and cons with each type of business vehicles. The main pro to the sole proprietorship is, of course, it's easy to start up and you are not subject to a heavy series of compliances. But of course, as a sole proprietor, your business liabilities is your personal liabilities, right? And moving on to the next one is partnership, right? I have this idea, but I do not have expertise in, let's say, marketing, right? I'm a lawyer, but I don't have the expertise in sales or marketing. I'm not a very good businesswoman. So what I do is I get my friends on board. Hey, why not we form a partnership? All right, can. So there are 2 types: conventional or limited liability. So be careful, everyone. If you want to engage your friends or family to form a partnership, it's very important for you to draft a proper shareholders agreement or a partnership agreement, right? So many people, they will think that, oh, come on, I'm just, forming a partnership with my friend. I trust my friend. So yes, no matter how much you trust your friend and families, always get everything in black and white. Yeah. And finally, this is the most common type of a business vehicle in Malaysia. It's what we call a company, right? From all of you from a legal background, you will know that we have this concept called a separate legal entity, which means that a company is a legal person itself. It is different from a sole prop or partnership, right? So we're moving on to the next one. So where do startups get the money from, right? The funding. So of course, there are various ways: bootstrapping, government loans, government grants, equity crowdfunding, angel investors, and we have a tax incentive as well, right? So the government loan, just now we talked about, the Malaysian government is supportive of the startups ecosystem in Malaysia. So they launch program like a soft loan, graduate entrepreneur, and even they have this Indian community development program as well for Malaysian Indians, yeah? So the equity crowdfunding, all right, just note the question, right? All the equity crowdfunding in Malaysia are regulated by the Securities Commission in Malaysia. So let's say, next time you would like to invest in a startup in Malaysia, right? And then you pump your money into this equity crowdfunding. So always ask the platform, whether you are regulated by the Securities Commission Malaysia. If they say they are not, please run away. It means that it is not not a legal platform, right? Always get one which is regulated by the Securities Commission Malaysia. Okay.
Ma'am, can you elaborate on bootstrapping?
Oh, sure. So the bootstrapping is essentially funding from family and friends. You are not relying on, the third party like, government or equity crowdfunding or the grants or angel investors, venture capitalists. It's basically just, I want to keep my business small. So I just borrow from my friends or, my husband, my wife, or it's just bootstrapping. Yeah. I hope that clears.
Yeah, ma'am.
Okay, sure. So in Malaysia, we have this act called the Companies Act 2016. So just now we covered that a company is a legal person itself. Why? Because this concept called separate legal entity. Of course, there are rules and regulations that the companies, the directors, their company secretary, their auditors have to comply with. So what are those? So keeping of accounting and records. This is one of the most serious mistakes made by startups, right? Because startups, they are small. And in a way that they may not be organized as, MNC, multinational company, they are organized, they have a separate sales department, they have a separate accounting, they have a separate regulatory department. But a startup, they are small, and most of the time they do not have the sufficient manpower, or they are facing financial difficulties. They're trying to cut costs. They do want to have a lot of overhead. So what they do is they may just, they are simply not aware of the compliances under the Companies Act, right? So under the Malaysia Companies Act, they have to keep a true and fair profit and loss account, and also keep all the records to enable them to be conveniently and properly audited, right? So why is it that, there's this a true and fair profit and loss accounts? Because in Malaysia, there are some companies, even though they make monies, but they try to, in a bid to evade the tax obligations, because the more profit you make, the more taxes you have to pay. So what they do is they will bribe their auditors to try to, give an inaccurate profit scenario of the company. So that is against the law. So all the appropriate entries must be made within 60 days from the completion of the transactions, especially the high growth startups, right? Every day they are changing, they are growing very aggressively. Sometimes the entries that for example, they just put it aside and then nobody remembers it. And by the time the 60 days lapse, nobody knows where is your receipt, where is your accounting book. Everything is a mess. So which is why, regardless of the size or the expertise of your startup, always remember these are your financing accounting regulations, right? The next one. And records must be retained for 7 years. You cannot, for example, right, startup, you start from a very small office. So 3 years down the road, you want to move to a bigger office, all right? And then when you move to a bigger office, you leave all your old accounting books over there. No, cannot. It must be retained for 7 years. Why? Because it is required by the Inland Revenue Board Malaysia that you have to
ma'am,
retain
where
for 7
should
years.
we keep this registered records? Is it to be kept in the registered office, that small one, or the one to which we have shifted?
Bring together with you when you shift to the bigger office. Wherever your registered office is, it must be with you.
And what is in the case of venture capitalist? Means if we are doing a startup and just for a particular venture, okay, so in that case, where we need to keep the books of accounts?
Sorry, your question is, what if the statements is with the venture capitalist?
Venture capitalist firm, where we need to keep the books of accounts.
Under the Companies Act, it can keep with a registered office, and also it can keep with you, as long as when you are being queried by the appropriate authorities, you will be able to produce evidence to show that, look, these are the true and fair profit and loss account, all right? Basically, they just want you to be able to show them immediately. So which is why they want you to keep this with you, as long as it's not with any third parties or it's lost altogether.
Okay, ma'am. Okay. Thank you.
No problem. All right. So financial statement, this is more to do with a deadline. So the duty of directors is they have to prepare financial statements within 18 months from the date of incorporations. Yeah, or once it has been incorporated already, you have to submit it within 6 months of each financial year end, FYE. Okay, and also the next step is it must be audited. Right, you cannot just send an unaudited financial statement. It must be audited before being sent to every member or shareholder. So again, the Companies Act, you always if you read about the Malaysia Companies Act, they always emphasize on this: give a true and fair view of the financial position. Because again, why? Because they don't want you to skip your tax obligations. Yeah. So which is why in the name of a transparency, the financial statement must contain how much the directors are paid, right? Directors' salary, remuneration, what are their benefits, what are the loans. Yeah, so all this must be clearly laid out in the financial statements. So this is how the Malaysian Act take financial statements very seriously. Not only it must be approved by the board, it must be accompanied by with a statutory declaration by a director, setting forth his opinion as to the correctness of the financial statements. So why they need a statutory declaration? Because under the Malaysian law, if you, let's say, you pledge something on a statutory declaration, if later on it was found out that the contents of the statutory declaration is false, it will be an offense punishable under the law. Yeah. So which is why they want not only a financial statement, they want a statutory declaration by the director as well. So,
ma'am, what does the statutory declaration contains of? Like, what all the contents inside the statutory declaration, which is to be given by the directors?
Basically, the statutory declaration is basically the content will be something like this. I, Lee Jie, I am the director of this X private limited company, and I confirm that the financial statements, to the best of my knowledge, are true and current as at the date of this statutory declaration. Basically, they just want you to affirm that it is correct.
Okay.
Yeah, there's no misrepresentation or whatsoever.
Okay, and ma'am, what types of auditors do the auditing of the financial statements? Is it the independent auditor, or the auditor, anyone in the firm can be an auditor, or there need to be a degree having a chartered accountant can only be a auditor, or what kind of law is in Malaysia?
Okay, in Malaysia, right, auditors, they are regulated by their auditors, what is it called? There's this organization governing the auditors. So it's in Malaysia, they are licensed auditor. It's not someone who is a fresh graduate or, just a let's say a clerk or secretary. No, they are a proper auditor.
So then there need to have a degree of auditor, right? There might be some degree. So chartered accountant can be an auditor in Malaysia?
You may. So you have to sit for certain exams. Once you pass the exam, then you can become an auditor in Malaysia.
Okay, ma'am. Okay, thank you so much.
No worries. So not only that, the final step is the company will lodge with the registrar. So the registrar in Malaysia, we call it the CCM, Company Commissions of Malaysia. I believe it's India is called MCA, Ministry of Corporate Affairs, right? So this commission or this ministry governs the workings of all the companies in Malaysia or in India. So they will lodge it with the registrar for them to enter into their record. So there are various ways where, for example, this startup is doing very well, right? Of course, there will be exit strategies. So what is meant by what are the ways where a company can opt for an exit strategy? One is M&A, mergers and acquisition. Of course, another way is IPO, initial public offering. So meaning that you want to get your company listed on the board. So in Malaysia, there are 3 ways to do so: main market, ACE market, and also the lead market. So this is a big topic. So I think if you need another session for this. So for the purpose of this this webinar, I will just keep it short. So these are 3 types. So you see here, leading entrepreneur, accelerator platforms. This is the most common way where startup will want to get their business listed in Malaysia. All right. So the next one, So this our Malaysian government is taking this very seriously. We call it the anti-bribery and corruption. So much so that they make this a corporate liability. So, in the Section 70A of the Malaysian Anti-Corruption Commission Amendment Act, so this is a new law. So basically, it says that a company may be held criminally liable for the acts of corruption by its director, employees, or other associated persons if they give any bribe or gratification with the intent to obtain a business or advantage for the commercial organization. So I give an example, yeah. I set up this company, yeah. I set up this startup, okay. So startup, especially those who are high growth, aggressively, they are expanding aggressively, so they want to get business, right? Sometimes they, when they are so into getting a new business, they may forgo their integrity. So what they do is they will bribe, they will bribe their tender, they will bribe the contractor. Come on, can you please give me some new business? All right. So unfortunately, it is not uncommon in Malaysia for them to do so. So which is why recently the Malaysian government has introduced this corporate liability. So for example, let's say I own this company. All right. So I have this employee. I've never interacted with him. All right. And this employee bribed the contractor to bring in business for my company. So can I say that, oh, I'm so sorry, yes, this person is my employee, but he's doing this without my knowledge. So, okay, I have nothing to do with this. Can I say that? The answer is no, because this is a corporate liability. So you'll be wondering, oh, does it mean that there's no offense for the company? There is. All right. So the associated person, including director, employees, and third-party shareholders. So what is the defense? So before I go to the defense, so as you can see, it is a heavy penalty, a fine not less than 10 times the value of the bribe. So let's say I bribe, the officer 1 million USD. So the penalty will be 10 million USD, right? So this is how, the government is taking this very seriously. And there's also imprisonment not exceeding 20 years. So the defense is very important for all of you. You are in the startup, especially if you are the founder, you are very busy. You will not have the time to sit down and to educate them, what is the importance of this anti-bribery law. So the burden of proof lies on you, the startup, the company, to prove that adequate procedures were communicated, implemented, and enforced effectively. So how do you do that? The concept is trust, TRUST. T stands for top level commitment. Right? You are the director of a company. Yes, you are very busy, man. I know that. All right? You do everything on your own. But that does not mean then you can be ignorant of your staff, of your employees' negligence or mistake. You must be committed to educate your staff about this anti-bribery law. And also risk.
Ma'am, in Malaysia, if the director commits some offense, one director commits some offense, is the another director held liable for the same? Because as you told, if one director does some offense, it comes on the company. Its company is liable for the same. So if company is liable, indirectly the directors are liable. Okay. So if for the fault of one director, all others have to face the legal issues. So is it like that? All others have to face?
Okay. Just now you mentioned about whether if director A commits an offense, whether director B or C will face the same penalty as well. If in the case of company, the answer is no, because the company, there is this concept called separate legal entity. So meaning that only the company will be liable. So what happens, the scenario that you spoke about just now will only happen in the case of partnership, which is the second business vehicle that we talked about just now. So a partnership is different from company, because a partnership does not have this concept called separate legal entity. So I am a partner, so I commit a crime. I commit an offense. So all the other partners will be equally responsible, will be equally liable as well. So that is partnership. So which is why just now, we always stress that, if you want to enter into a partnership with your friends and family, don't be shy. please get a lawyer to help you to draft your shareholders agreement or partnership agreement to clearly lay down, what are your profit sharing, what are the rights and obligations of each partner. Yeah. So as a lawyer, I've personally seen, so many business relationships break down because of lack of this partnership agreement. Yeah. I hope that answers your question.
Yeah, ma'am. Thank you so much.
No worries. Sorry.
Anyone else from the students, if they want to ask any questions, you can surely ask, ma'am.
Sure, no problem. All right, sure. And also undertake control measures, systematic review, monitoring, and enforcement, and lastly, training and communication. So, sorry. So these days, right, I'm happy to see that, many companies in Malaysia, they are actively engaging lawyers, to give a talk to their staff, especially those from the sales and procurement departments, right? Not to say that, they like to, give out bribes, just to say that they are in a dangerous positions because they are the business making department of the company. So what you can do is each time, next time you are the founder of a startup, you have to get maybe you can engage a lawyers to give a training, take photo, and also you maybe record the video as a proof that it is part of the training and communication. Okay. Again, to ensure compliance with this Section 78 MSCC, so you have to implement as a founder of a startup. You have to implement from the very beginning. Implement an anti-bribery and anti-corruption policy. You can get a lawyer to draft the policy and to define what is considered as anti-bribery and what is not. All right. And then you have to, from time to time, you have to review the existing set of anti-corruption policies, especially when your company expands. You have more and more departments. Naturally, you will want to review the policies. And then you have to address any gaps. And also, again, conduct and assess anti-bribery and anti-corruption training. And also conduct due diligence as well, especially, for example, you want to engage a third-party vendor or to engage, or for example, even before you hire anyone, you have to do your due diligence, how is that, do they have any criminal records, and to do the KYC, know your clients, know your customers, checks. Yeah. Yeah, I have come to the end of my presentation. I think I have taken up like almost half an hour. I'm so sorry. Yeah.
No problem.
Thank you so much again, for having me. So my name is JJ. So feel free to connect with me on LinkedIn.
There was slide number 3 or 4.
Sorry. Do you mind repeating your question again?
Graduate Entrepreneurship Development Program.
Oh, graduate. This is the second one, right?
Yeah, exactly.
Okay. I do not have the full details of this program, but what I believe, if I recall correctly, this is a grant provided by the Malaysian government to fresh graduate for them to. The aim is to encourage the fresh graduate to set up their own business. It is a grant, they give money to the fresh graduates for them to, to explore into the startup scene. Yeah, it's a one-off thing. Yeah.
This kind of loan has an interest rate on it, or is like completely free of interest for the graduates?
Okay, this one I do not have the full facts yet because maybe I will reply you later. After this webinar, once I read this graduate entrepreneur development program again. Yeah.
No issue. So anyone, any queries for JJ? Okay, then. Vriddhi, you may proceed.
Yeah, sure. Just 1 minute. Okay, so I would like to thank JJ for this amazing and enthralled speech. As she mentioned that her name is JJ, so I am telling it as JJ. And thank you so much for giving a wonderful speech which enthralled the hearts of our students. And thank you so much for having thank you so much for giving an amazing speech and making our platform a wonderful what I can say, a wonderful place.
Thank you, Riddhi. Thank you, Shravan. It was
You're welcome, ma'am. You're welcome. Now I would like to invite CS Devarshi Gupta, a practicing company secretary from NIRC of ICSI, to commence his speech.
Hello. Hello.
Yeah, sir. Yeah, you are audible.
Can you confirm whether I am audible?
Yeah, sir, you are audible.
Okay. Then I'll start. I'd like to thank Shravanji and Riddhiji and team behind organizing such informative conferences, first of
Thank
all.
you so much, sir.
My greetings to fellow speakers and attendees. Myself, Devarshi Gupta. I am practicing company secretary in Indian state of Uttar Pradesh. Being a legal financial professional, we regularly come across various startups, angel investors, and venture capital funds. In my short journey till now, I have come to form my opinion that for development of a healthy startup ecosystem, one of the most significant area where improvement is required is funding of early stage startups, which are looking for seed funds or startups in revenue stages. So what is the problem, actual problem in funding such startups? Actually, these startups, or as we call it, early stage bootstrapped companies, are generally either at idea-based company or they have not yet generated revenue. So it is very difficult and unfair to assign a valuation so early in the life cycle of the company. So to solve this problem, I would like to bring to the table concept of safe notes and its Indian version that is being used in India. For the people who are not familiar with the safe notes, SAFE is an acronym for Simple Agreement for Future Equity. Being around the startup world, especially early stage companies, anyone must have either run into or heard about these notes. These instruments have gone through a bit of evolution and offer companies and investors a different path than traditional equity or debt instruments. In around 2013, a Y Combinator, a seed money setup accelerator, introduced this note to help early stage companies raise money. The focal point was that these notes are flexible. Unlike traditional convertible notes, they were not flexible and was causing a lot of problems for founders to run their business. So they came down and stripped down the convertible notes to the safe notes, and these were born. To understand what safe note is, first thing to understand is what it is not. A safe note is neither an equity nor a debt. It's just a simple promise to issue future equity as long as certain terms are met. In some technical term, it is a non-debt convertible security. In simple terms, an investor will give money to a startup and receive a promise to get equity in future when certain milestones are met. Usually, price of such equity is predetermined, in which the conversion will happen.
Sir, but why will a company give money to a startup who is promising to give equity in future? Means there is no.
Yes, ma'am. We are talking about early stage startups. There is no revenue generated till now. There is a lot of risk involved. No, it is not for all individuals or companies to invest in these companies. These are just idea-based companies, and investors are taking a huge risk.
So why would investor take that huge risk? There might be some returns or something.
Yes, ma'am.
Just for that equity.
And when you invest in these early stage startups, there is a huge growth opportunities. We have seen so many startups till now who have multifolded the fortunes of many funds.
So, but there is another angle to it as well, because every startup is not an
That's
what I
the
can say,
inherent,
a business.
yes, ma'am.
Every
That is
startup
the
doesn't.
inherent risk in investing in startup ecosystem. If
Okay.
someone is in trying to invest or willing to invest in startups, he must be willing to take the risk. That's the inherent risk, and no one can avoid that or evade that.
And if the startup is not able to earn profit, and they are not able to return the money, then what are the compliances they may face?
I'll come to that in my presentation after some
Yeah,
time.
sure, sir, sure.
So let's continue there. Uh, what are the benefits as of safe notes? I'd like to mention or highlight some of them. Most safe notes have a valuation cap. It is for from point of view of a investor. A predetermined valuation as to what the note will convert to in equity is determined, and it is written in the agreement that is executed between the investor and the company. This uh, it is a very important clause. It creates a certain limit or range on the valuation of a company. Safe notes may be issued on a discount. That discount is also predetermined, and it usually is connected with a triggered event. Whenever that event occurs, a triggering event, it is safe notes are converted into equity at that predetermined discount rate. Mostly, these triggering events are new round of funding or any merger acquisition that is happening. Safe notes, the most important point of safe note was no maturity date. There was no fixed date on which these promises will be fulfilled, or as you may say, the safe notes will be converted into equities. A safe note does not mature after any time limit. According to the originator who created this safe note idea, according to Y Combinator, a safe is designed to expire and terminate only when a safe holder has received a stock in event of equity financing, cash or other proceeds in case of liquidity of a startup or dissolution, whichever occurs first. The purpose of all these features is to make things as simple as and as clear as possible for the startups. As you may know, these are we are talking about early stage startup. They don't have the money or the resources to employ any lawyer or get services from big legal firms. The main point or main focus point was to make things simple for these startups. Now we should get to the benefits of the startup company, the company which is getting the investment. As you may know, Safe Note is more or less a onerous gift, where investors don't get equity or any other benefit, but are given only a promise. That too, without any hidden condition or terms and condition. Normally, there is no interest payments or any agreed end date or maturity date. In other words, Safe Note can does not have any set time. There also usually isn't requirement to pay back the principal if the company fails or isn't purchased. There is no requirement to pay back. A safe note provides an influx of the capital without restriction of the covenant, promises of repayment or initial control or dilution issue of direct equity issuance. Even the control of the company, equity holding of the company remains the same. So founders are in total control of the company. Let's come to the point when safe are converted into equity. Mostly these are a triggering event which are mentioned in the safe note or agreement, whichever is executed at the time of investment. Mostly these are next round of funding. So one of the most valuable benefit is clarity of how much equity is being issued. In many convertible debt notes, which are traditional debt notes, conversion price and amount can be opaque, anything, vague. There is no certain written limit in terms of conversion, especially if open round of funding is involved. Unclear paperwork causes confusion whether conversion price is pre-money or post-money of the new issue. If there is an open round, your valuation is post-money, you technically can't convert until the round is closed. So payment get delays and investment get delays. So a startup may suffer from that. Safe Note provides ease of entry and startups comfort. If you are a seed or early stage investor, a safe note is the easiest way to invest in a company without much paperwork and efforts. Now the question arises, if we take this concept and try to implement in the Indian legal and financial ecosystem, how will it work? The answer was given by a venture capital fund named 100x based out of Mumbai. They introduced iSafe notes. Actually, the safe notes, the idea and the features were not legal, were not according to the Companies Act of India. They were according to the US law. So they changed a few bits that I am going to explain. To comply with the applicable Indian law, iSafe notes take the legal form of compulsory convertible preference shares, which is convertible on occurrence of specified event. It could be a time limit that cannot exceed 20 years. It could be any event that the investor and the company decides. iSafe, apart from the above features that I have told you, have some distinctive features too. First is valuation. Since these are early stage bootstrap companies are generally at idea or MVP, as we call it, minimum viable product, or very early revenue stage, and it's unfair to assign a valuation so early in the life cycle. So iSafe notes do away with the need to state pre-money or post-money valuation. There is no valuation decided at the time of investment. It will be decided according to the terms and conditions written in the investment agreement, but it is not decided exact. As the equity in favor of iSafe note holders is issued much later at an equity pricing round, once the startup has achieved some stable or sustainable revenues. Second point is control or investor interference. Since the investor gets preference shares, founders are free from any interference. They can control the company as much as they want. In India, even at seed stage funding, angel investors or VCs use big fat one-sided agreement with entrepreneurs. iSafe notes do away with that, and it is only a 6-page or 5-page simple agreement, which is very favorable for entrepreneurs and involves around negligible legal costs. And iSafe is in India is not a debt or equity. There is no interest accruing, though for a legal compliance purpose, iSafe note carry a non-cumulative dividend at the rate of 0.1% or 0.001%. In India, if the startup fails, whatever the money is left after discharging all its liabilities will be returned to the iSafe holders, not the founders. iSafe holders or the compulsorily convertible preference shares holders get preference over the equity shareholders or founders. This is one of the most important distinction between Indian version. As I talked about earlier, US version does not have any preference, does not have any maturity, but iSafe have a maturity. They cannot exceed 20 years and 30 years in case of infrastructure companies, and they have a preference over equity or over founders. That I think that answers your question, Riddhi ma'am. Am I correct?
Yeah, that answers my question.
Okay, ma'am. Well, this marks my time. Thank you. Thank you for providing this platform to me. I'm hopeful that I was able to convey some useful information to you also.
I had a question with Gupta. Actually, yes,
Yes.
so I directed it, but again about the clear inception of that. Tool into the incorporation industry, and company secretaries are a bit specific about compliance, right?
Yes.
So it's like if you don't do compliance, you will have this. Like there are penalties for that definitely under CRPC and other sections. But like as many founders or entrepreneurs try to avoid compliances, the major reason for that is the pricing. So, what is the estimated pricing according to you in the market for incorporation and such related compliances? The founders generally like try to avoid that.
Sir, there is no specified price actually. It is about the work we do. How if I am going to incorporate a company, I have to go to a company secretary to make sure my objects are good. He has to ensure and vet my memorandums, my article that are going to be the internal laws of the company. The company is going to be governed according to those laws. So I think whatever a professional is charging, he's charging according to his expertise and time value. So everything is good, I think.
It's like approximate.
Approximate, I would say around 15K. It's just a numbers game. Anyone could be charging anything.
Okay, thank you. Actually, this was a question of quite controversy.
Okay.
So, nonetheless, I would like to thank CS Devarshi Gupta for his amazing speech. Riddhi, do you have any other questions for her?
No, I don't have any questions now.
Okay.
So we can move
Uh,
forward.
Attendees, if you have any questions, you may type it out in the chat or may direct it at them after muting yours. Yeah, Riddhi, you may continue.
Okay. Now I would like to invite CS Anushka Damani from Hooghly chapter of EIRC of ICSI to commence a speech.
Thank you, ma'am, for such a warm welcome. I am CS Anushka Damani, a practicing company secretary from Kolkata and a law graduate. It's a delight to have young entrepreneurs in this virtual hall and to have a meaningful and a learning session with them and to be a part of it as a guest speaker. Thank you, SK Associates and Group, for the opportunity. So the topic for the day is financial compliances. But before we commence our discussion on the same, let us understand what this compliance means and why it is important to comply. So in my opinion, compliance to an organization is just like a healthy diet to a body. Eating healthy is important for a fit life, but we all know a creamy cupcake brings delight to our hearts. However, it comes with lots of calories and sugar. And so we have to be honest that doing the right and healthy is not always fun. Longevity of the life is important, and so is the longevity and sustainability of the organization. The compliance is also that healthy and necessary diet for a startup. Rather, I would say that it is more than just eating your greens. It means abiding by the laws, abiding by the policies, regulations, and many other rules. It helps a startup to become a high performance machine from its very roots. Adopting a good diet regime is equal in investing in the programs of success. Hence, compliances are necessary and also inevitable. Now, coming back to our topic, which is financial compliances. So, what it is? It also means abiding by the laws and rules, but they exist in the financial market. Now, again, before I commence what are they for the startups, we have to understand what are startups. Any new business which has just begun is a startup? No. DPIIT is the ministry that defines and recognizes the definition of a startup and recognizes a new founded business as a startup. So they are built on few parameters. So what are the parameters to become a new entrepreneurial venture is becoming a startup? What are those parameters? The number one is the scalable model. The next one is the technology, the basis from where we are taking our startup. And the third one is the innovation, the growing innovation. It is not that you have invented a product and you are scaling a business on that. No, the product has to be keep on updated. You have to keep on updating the product and keep on bringing the new innovative ideas to be consistent, to be a consistent startup actually. So the innovative ideas are manifested into the products or services that are brought into the market for the validations, and then it keep on growing. So to be recognized as a startup is basically a challenging phase for every entrepreneur. Because it has...
Ma'am, is it necessary that for to be recognized as a startup, you should have an innovative idea? For example, if there are two companies with the same idea, then who can be defined as a startup? Both have the same idea.
So yes, the idea has to be innovative. Probably both the companies are having the same idea, but the way of making that product may be different. They both have taken two new formulations. They have patented two new formulations. So the process has to be innovative. It's not always the product. It's not always the service. It might be the process that is different and that is innovative. So
does it also depend on the amount they are earning, like the profits of the startup?
No, absolutely not. In fact, we see that mostly in the initial stages, the startups are either earning lesser profits or no profits.
Yeah, true.
So basically, profits are not the necessity, but to overcome this financial crunches, we have to make this organization a scalable business. And that is the reason scalability is one of the parameters that has been checked by the DPIIT to get a startup recognized as a startup, to get an organization recognized as a startup. And once DPIIT recognizes it as a startup, that is, you are having a scalable model, you are having all the parameters fulfilled, the technology, you are having that employment generation. The idea is that you are creating the employment, you are creating the wealth. But then also there are few conditions that has to be fulfilled by the DPIIT. That is, we all know that a startup should be in a form of a private limited company. It cannot be into a public limited company, or it should be in the form of a limited liability partnership or a partnership firm, conventional partnership firm. But it cannot be a sole proprietorship, neither it can be any other organization. So the DPIIT has restricted the form of organization to which acts as a startup. Secondly, the startup is recognized as such only for a tenure of 10 years. Thereafter, it is just a normal company. So all the benefits that are available to the startup in the financial market, in the legal market, is available till the tenure of 10 years. Thereafter, you cannot present yourself as a startup because the initial stage has been crossed. Now you're a normal company.
So ma'am, in this span of 10 years, if some company fails to abide by the rules, or the funding which they get somehow stops or starts getting losses, so what about that? Then that company is out from the startups, or there is some help provided to them?
If you are breaking any condition that is a parameter to be a startup, and if you're breaking that condition, so yes, you'll be out from the definition. And secondly, you said if they are breaching the threshold limits, that is, they are earning more profits than expected. So the turnover has already been defined by DPIIT that it has to be less than 100 crores in any of the financial years. So if you're breaching that threshold limit, yes, you will be out of that definition. So all the three parameters as well as all the conditions have to be fulfilled to be in that to fit in the definition of startup.
Okay, thank you.
And the very important one is that you have to keep on working with your research and development team. That is, you have to keep on improving your existing products. You have to bring new ideas. You have to make your business scalable. You have to create wealth. And your product, your service, your organization should be highly potential in generating the employment. This generation of employment has been added in the definition of startup because India needs more employment opportunities.
So, ma'am, can a startup change its line of business or introduce a new product within the 10 years of its period of defining it as a startup?
Yes, it can do that, but then also it comes with certain parameters and conditions. You are not making anything contrary with the scalability or with the innovative idea. Even if you're bringing a new object into the business, that has to be equally innovative. So the parameter should not be contrary to the newer idea.
So can they open a subsidiary of their own company?
Yes, we can open a subsidiary. That's not a problem. But startup should not be something that is created by amalgamation of two companies. Or it should not be a joint venture.
Okay.
So that will not be recognized as a startup.
Okay.
So when we are coming with so many conditions, they are small baby businesses with usually, as you said, less profits or no profits. So why these financial compliances are into picture? Even our government of India understands that small businesses should not suffer these heavy cost-bearing regulations, which are actually applicable to the bigger corporates. But the compliances are necessary because it brings transparency. It builds the trust with the investors. It recognizes the systematic and unsystematic risks of the organization. It helps in preventing the financial manipulations. So we understand that actually this financial compliances coexist with the legal compliances. It is a broad spectrum and is governed by many, many authorities, and sometimes it is governed by some industry-specific governments too. Anyway, coming back to the financial compliances, we'll be starting with some general ones. Like once you plan to open up an organization, you incorporate an organization, immediately you have to have a PAN registration and a TAN registration. That comes under the spectrum of financial compliances, to have a PAN number and a TAN number, because it is very important to yearly file your income tax returns. So that registration is the foremost need of a organization, of any organization, not only startup, but of any organization. Then secondly, the startup is also required to have the professional tax registrations, be it PTEC or the PTRC, that is the professional tax registration certificate or the professional tax enrollment certificate. So that is also important. However, it is applicable on very few of the states, but then it's another compliance for the startup. And many of times you'll see that even yours have been passed, but this professional tax registration has not been taken up because it's a very neglected compliance of the organization. This certificate has to be taken up by the directors of the organization because they are in the employment, and the registration certificate is taken up by the startup itself because startup is an employer to many of the employees. So these two registrations have to be taken, and then if you have taken the PTRC, you have to monthly file the returns and pay the taxes. If you have taken the PTEC, you have to yearly file the taxes. And the next one is the coming to the tax related provisions. The next one is the income tax compliance. So income tax do come with a lot of benefits, which also comes with the compliances, that is the self-assessment of the liability. If with the very beginning, if the startup is assessing that at the end of the year, the liability will be more than 10,000. So it has to pay the tax liability is more than 10,000. So it has to pay the self-assessment tax. It has to pay the advance tax. And the income tax return filings have to be done yearly. Then audit services. This is the most important thing that we have to understand. If you are getting recognized as a private limited company, a startup in the form of a private limited company, the audit is applicable from the very first day. But if you are getting recognized in the form of a limited liability partnership or the partnership firm, so there are certain threshold limits. Only on reaching those limits, we have to get our books of accounts audited. The startup has to get its books of accounts audited only on reaching those threshold limits. So for the limited liability partnership, the limit is if your contribution is exceeding, the capital contribution is exceeding 25 lakhs or your turnover is exceeding 40 lakhs. And similarly, in case of partnership firm, if your gross turnover receipts is exceeding 50 lakhs, then you have to get the books of accounts audited. So these are the general compliances, and hence we do not have long and large benefits or relaxations on them. But then income tax do bring some benefits also, which we'll discuss in the later half of the session, later half of my discussion. But very important registration that has to be done is the GST registration that has come into the picture since 2017. So every month we all have seen and we all have heard that every month we are making GST payments, we are filing the returns. So what is the benefit or what is the relaxation that has been given to a startup? With a financial crunch, what are the benefits they are giving? So GST has come up with two kinds of scheme, QRMP scheme and the regular scheme. So if your turnover is less than 5 crores, which is expected, that a startup will not have a turnover of 5 crores in its initial phase. So for such organizations, which includes a startup, they can go for a QRMP scheme where they have to file the returns quarterly instead of monthly. Although you have to pay the taxes monthly, but the filing of returns has been reduced. So you have to do it quarterly. Next, the regular scheme. Regular scheme is available for those who are not under the composition scheme. So even if you're having a turnover less than 5 crores, you can enter into a regular scheme. If you have the turnover more than 5 crores, you will definitely enter into a regular scheme. You don't have an option for that. And the last very important thing, which actually comes from the generation of employment opportunities, although it may not have been applicable on the startup if this point is not included, generation of employment opportunities. Being a startup, you can say the organization is very small, so I have very few staff members in my organization, very few employees. So ESI and EPF registration is not applicable on the company. But when the startup is said to be such an organization which is creating employment opportunities, it means that you are increasing your employees in the organization. And when you're increasing the employees to more than 10 or 20, in some states it is 20, in some states it is 10. So if you're increasing it more than 10 or 20, you have to have that ESI and the EPF registrations. And then it comes with the payment of taxes as well as the filing of returns. So these are the general financial compliances that come with the moment you start up a organization. You are in, whether you are into a startup or you're into organization, but you have to follow these compliances. So what are the benefits that are available? So we can see that there are several legal benefits, but since our session is restricted to the financial compliances and the financial benefits available, so I'll be discussing one of the financial benefit that is available under the Income Tax Act of India. One such benefit is the deferring of the TDS liability on the part of the employer and the tax payment by the assessee employees on the ESOPs given by the startup. So, what are these ESOPs? These are the employment stock option plans that are given by the startups to the assessee employees, to the employees of the organizations, to employees of the startups, so as to retain their talent. This is very important, to retain the talent, because when you are, it's a kind of perquisite. So when you are into a startup, into a new organization, it is very difficult to retain the trust of the investors and to retain the trust of your employees, that yes, this organization will grow. So to retain that, startups usually come with the ESOPs. Now, what is the benefit that is available to the startup when they are issuing an ESOP? So, in general, when we see section 17 of the Income Tax Act, it says that the value of perquisite is taxable in the year when the ESOP is allotted or transferred to the assessee employee. So, in the year when you are issuing the ESOP, the value of that perquisite, the value of that ESOP is going to be taxable in the hands of the assessee employee, as well as the TDS liability has to be paid by the startup employer. But and this leads to a cash flow problem for the employee also, and as well as for the employer also. Why for the employee? Because the employee is not ready to sell the shares immediately. He is going to hold it for a long time. So why it is necessary to pay the tax liability, tax payment on the very first year of getting that ESOP. So this has been understood by the government, and the startups are also having the liquidity crunch in the beginning. So that was understood, and to incentivize the startup ecosystem, Finance Act 2020 came up with an amendment which defers the TDS liability of the startup employer and also the tax liability of the employee to within 14 days from the specified date. Now the question is, what is the specified date is? So the specified date has been defined by the Finance Act, and it is earlier of the following dates. The following dates that I am going to discuss, it is earlier of them. So the number one, the date can be the expiry of 4 years from the end of the relevant assessment year. Now, what is this relevant assessment year? The year in which the ESOP was transferred or the ESOP was allotted. So, it is the expiry of 4 years from the end of the relevant assessment year, or the date on which the employee ceases to be employee of that company, or the date on which the employee sells his or her ESOP. So these are the 3 dates. So the earlier of it has to, so that earlier of it has to be the specified date.
Yes, sorry for the interruption, Anushka. Just one question from my side. As you mentioned, after reaching a certain point of turnover within the initial 10 years, startups, like once they exceed that turnover limit, they don't come under the category of startups. So in that sense, how could the unicorn startups be still termed as startups? Yeah, am I audible, Anushka? Am I audible, Riddhi?
Shravan, you are audible, but I guess CS Anushka Damani has left the meeting.
Okay, no issues. So yeah.
Can we move further or we should wait for
Yeah, you can move further, Riddhi, definitely.
Okay, fine. So I would like to thank CS Anushka Damani for her informative and knowledgeable speech. Now I would like to invite CA Hemant Gupta, a senior partner in Rao and MR, to commence his speech.
Sorry, ma'am, Riddhi, there was a network issue on my end, so I just got disconnected.
Yeah, ma'am, not an issue. We'll take you further. Now we are inviting another guest, and once he's done, Shravan has one question and he'll ask you, and you can solve his query.
Okay, thank you.
Hello, am I audible to everybody?
Yeah, sir, you are audible.
Okay, great. Before I start with my presentation, I must congratulate my previous speaker. She gave really an elaborate presentation, and I think our quite a few area will be overlapping because startup legal framework is same in India. So before starting with the presentation, I would like to thank the host of this who are organizing this conclave, SKNG, and especially the coordinator and host, Ms. Riddhi and Mr. Shravan Kumar, for making this event possible and handling the presentations and communicating with the speaker so in a well laid out manner. Thank you so much, guys, and thank you so much for giving me this opportunity to interact with you on such a vast platform. So I'll start with my presentation. So before we start with the legal compliances of the startup, I would like to point out what is the definition of startup. See, I think our previous speaker's connection got disconnected, so she was not able to answer Mr. Shravan's question. So with the permission of the house, I'll take that question first. See, there is no standard definition of startup, and the startup definition is given by the government of India. They have their own frame of mind, their own scheme of things to categorize one company as startup and another company not as a startup. So unicorn, definition of a unicorn would be on a global scale, that even after being a unicorn, you are still a startup. You are being called a startup. But as far as the government of India's regulation are concerned, they have given a threshold of 100 crore rupees, I believe that is the amount, so that once you reach that limit, government would not be supporting you as a newly formed startup. So that is the difference. So you would still be a startup in a global connotation, but as far as the government of India is concerned, they will not be treating you as a startup. So I think that answers your question. So what would be the parameter given by the government of India as a startup? See, you can either be a private limited company as defined by Companies Act 2013. You can be a partnership firm, you can be a registered partnership firm or an unregistered partnership firm as well. You can be a limited liability partnership, LLP, which is commonly called, and you can be a one-person company. So these are the legal constitution of various businesses you can take up in order to be recognized as a startup. Even though you can start a business as a proprietorship concern, or for that matter, unregistered partnership as well, but that will not be treated as a startup as per Government of India startup schemes. Okay. So, as my previous speaker also mentioned, what is the basic criteria which the government has taken up? It is that it has not completed 10 years since its inception or registration. So it should not be more than 10-year-old company. Already existing company can be a startup, but the time frame for their existence should not be more than 10 years. That should be less than 10 years. Turnover in any of the financial year has not exceeded rupees 100 crores. So that is again in Indian context only. Thirdly, it is working towards innovation or development or improvement of product, process or services. So there has to be some innovation, development or improvement, some existing. You cannot make a trading company and call it a startup, even though you might have incorporated it just now, maybe a year back or maybe a month back, but it will not be a startup merely because it's not doing any innovation, development or improvement of any process, product or services. So that has to be the core of that startup. Again, there has to be scalability of the business. It should not be like that you are doing some certain kind of business, but that is not scalable. So scalable business model with high potential of employment generation or wealth creation. Either you should be able to generate a lot of employment or you should be able to generate a lot of wealth. Even might not be employment, but wealth creation has to be there. So it's a either or condition. Then again, you have to obtain a certificate from interministerial board set up for such purpose, which is DPIIT for this case. Then again, there should not be a reconstruction of any existing business or splitting of existing business. It has to be new business, not suppose you are already carrying on some business and you split up that business or maybe make a subsidiary or something of that sort. So that should not be allowed. That will not be allowed for that purpose. Then coming to legal aspect and compliances that every startup should know. See, we can categorize this requirement between few broad heads, like incorporation related compliances, business license related compliances, documentation related, then perhaps company law based, income tax based, GST based. Then there are labor law based compliances are there. Then you might be requiring some legal assistance or technical assistance to frame certain kind of documents, maybe employer employee agreement, no non-disclosure agreement, client various form of agreement between your vendors and your prospective clients. So these kind of compliances might also be required. So I'll start with the beginning. So if you are incorporating your company, you're incorporating as a company, then you might need to register yourself with Ministry of Corporate Affairs under Companies Act. For LLP also, you need to register with Ministry of Corporate Affairs. The nodal ministry is same for both these kind of entities. For Partnership Act, there is no entity as such, but you need to be registered with Registrar of Partnership. There is one form, I believe Form A is there. That is a proof of proof of registration of your partnership deed. Then moving on, what kind of business licenses might be required by you while entering into any startup? So see, first and foremost, common type of license would be required is shop and establishment license, which each and every state in India governs that these licenses in order to regulate the place of businesses. Then you might be requiring GST registrations. You might also be requiring professional tax registration in depending upon which state you are having your head office. You might be requiring, in case you are dealing in some food stuff, food safety licenses, health trade licenses. In case your business has something to do with liquor, you might be requiring liquor licenses. In case you are dealing with some environmentally hazardous material, then you might be requiring environmental clearances as well. So the documentation which I was talking about, what kind of documentation would be there? So documentation which you might be requiring during the process of your journeying from a startup to a fully blown company, having a fixed or a steady stream of income and good steady bottom line. So these are the document. These document. What could be the document? This document could be founders agreement, the agreement between, suppose 2 or more people are incorporating or venturing out with a new idea. So founder agreement could be there. Who holds what kind of equity and what will be their rights. Shareholder agreement could be there for, in case you have already made a company and somebody new wants to come into the picture as a shareholder. So you can have a different agreement with them, shareholder agreement. What would be their right, what would be their responsibility, how and when they will be bringing in the money, and what would be their exit route. Memorandum of association is there. You need to frame a memorandum of association depicting the object of your entity, article of association depicting how the internal working of the company will be carried out, what will be the resolution percentage, special resolution will be there for what kind of business, ordinary resolution will be there for what kind of business. Non-disclosure agreement you might be requiring to deal with various stakeholders of your company. Confidentiality agreement are required. Memorandum of understanding might be required to be framed with your counterparts. Letter of intent, employer-employee agreement would be there. Lease agreement would be there. Service agreement, consultancy agreement. These are the type of agreement which you might be requiring as a standard template, so that whenever someone requiring or someone falling within these broad categories come to deal with the company, you are having something to fall back on, something to refer, so that you can at least give that person this kind of agreement that these will be terms and conditions of our relationship. So again, a very important aspect of company policy on sexual harassment has to be framed. Employee grievance management has to be framed. Data privacy, whistleblower policy has to be there. Then intellectual property, which is a very which might be the special source in any company or any new startup. That management has to be there. You need to register. You need to take a conscious call whether you want to register your intellectual property like copyright, patent in particular, because I believe while registering your patent, you have to also disclose how the patent, how the design works, how the product works. So you might not be interested in sharing with the world if you are having any proprietary technology. So that is
Sir, I have one question
Yeah, yeah,
actually
please.
about this patent. You talking that we have to take patent rights and trademark certificates. So patent rights, if your patent or your trademark matches someone else design, right? So how much period you will be given to make the new trademark, new design?
No, I think for trademark you need to apply for trademark you need to apply, and immediately you can start using it as a trademark. And that there is a process period of I believe from 2 to 3 years within which people usually object to your particular trademark, so that the industry, because they'll be publishing that trademark in their trademark journal and whatever the publication which this department comes up with. So if
Okay.
anybody wants to object on that trademark, they can object, and within a period of 2 to 3 years, if there are no objections, or in case of any objection, you have successfully litigated those objections in your favor, you'll be given a trademark wherein you can use it as a registered trademark along
Okay.
with the name. For patent, I think also you have to prove I'm no expert in getting patents registration, but I think you
Yeah.
have to prove that this patent, this innovation is yours.
So
So
basically, we have to go through the litigation process for that.
you might have to. It's not the case that every time
Okay, so we
there
can
will
go
be
for mediation
litigation.
or arbitration as well, right?
Sorry.
We can go for mediation and arbitration as well in this
Um,
case.
See, it usually doesn't pan that way. Suppose you have registered one. Let us say you want to have a name Reliance. We all know Reliance is a very big
Huge
conglomerate of our
company.
country. So Reliance, you would, if you want to use the word Reliance in your company's name or your product's name, Reliance would not be mediating with you. Reliance would want to enforce its trademark right on you, and they would want to withdraw that name.
So
So it's
basically,
not
it
in
would
every
be
case there will
between
be
two small
mediation.
companies. Means if it is a huge company, then obviously mediation and arbitration would not be possible. But it is if it is with the same level of the company, then you can go for mediation and
No,
arbitration as well.
again, I would say it's not. It doesn't depend whether the company is a huge or small. It's a matter of having a right. Suppose I am an individual. Let us say there are people in the market who get various trademark or various designs or logo registered in their name just for the sake of it. They are not doing any actual business with that. Or for that matter, they register the name of a website. You're getting my point. So
Yeah.
suppose tomorrow I want to go and buy hemangupta.com. Riddhi might have already bought hemangupta.com. So I would not be able to use hemangupta.com website unless and until I buy the right from Riddhi.
Yeah.
I cannot mediate or litigate with Riddhi like Hemant Gupta is my name. How can you buy this website? It was legally available. You bought it, so you have the right over that domain.
True.
So that is how a mediation would not be required, I believe, in most of the cases. If you have a valid legal right, it has to be enforced through proper legal channels.
Okay. Thank you, sir.
Okay. So moving on. See, now there are 2, 3 more heads of compliances which might be required. One is company law based. See, once you registered as a company, or for that matter an LLP, there are some compliances which are required by the Ministry of Corporate Affairs, or for that matter LLP Act or Companies Act 2013. So in case of a company, you need to do annual general meeting, which is not the case with in case of LLP. There is no annual general meeting required in case of LLP. So for newly incorporated company, you can do the AGM within 9 months of it from the end of the year. For other company, you have to do AGM within 6 months from the end of the year, and there should not be a gap of more than 15 months between dates of 2 AGM. You can take an excuse of 3 months by filing an application with the registrar of companies and taking a plea on certain account that you are not able to conduct AGM. So that can be allowed by them in case of any exigencies. Then board meetings are there. Every half year there has to be 2 board meeting, and between 2 board meeting, the minimum gap has to be 90 days and maximum gap has to be 120 days. Further, director of the company are required to file a form DIR1, DIR8, which is mandatory filing of form. Then form ADT1 is there. Once you appoint an auditor, mind you, auditor has to be appointed within 30 days. By the first auditor has to be appointed by the board of directors. So once they conduct the board meeting, they will have to appoint the first director. Then subsequent director can be appointed by the shareholders in the annual general meeting. So that auditor appointment goes for 5 years, unless and until that auditors resign or some valid reasons the auditor is removed by the management of the company, or for that matter shareholders in EGM. Then for annual compliances, you have to file form number MGT7 and AOC4. MGT7 is for annual report of the company, mentioning director report, notice, and those kind of things. And AOC4 is for filing of financial statement with the registrar of companies. Then MBP1 is there, compulsory MBP1 is there, which is a form which is these DIR 8 and MBP1 is basically they form relate to mentioning about directors' interest in a particular concern, directors' financial stakes in some other companies. So these forms are required to be filed with registrar of companies. Then in case of a LLP, you need to file form 8, which is a form annual statement for which is a statement of account with ROC before 30th of October of every year. You have to file it for the preceding year. And then form 11 is there, which has to be filed within on or before 30th May of every year with ROC, which is the annual return for each year, which is form 8 is similar to AOC4, and form 11 is somewhat similar to MGT7. Not exactly, but somewhat similar. On similar lines, these forms are there. And there is no requirement of holding any AGM with in case of a LLP. Now coming to taxation-based compliances. In taxation-based compliances, what we have to do is, like, you can get a tax holiday of 3 years under section 80 IAC. So within a period of 10 years, you can choose any 3 years for having the tax holiday. You will not be charged a single penny of income tax by the government. Further, certain long-term, certain exemptions have been provided on long-term capital gains. For example, in case I as an individual sell certain assets and want to invest into equity of an eligible startup, then I have to invest in minimum 50% of that equity. Then my capital gain will be exempt to that extent. But I cannot sell that investment for next period of 5 years. Further, in case the tax exemption is also there in case the
actually your screen is stuck, I think. Yeah, is it just my problem or is Mr. Gupta's
No, yeah, it's Mr. Gupta's problem. Actually, screen is stuck.
Okay, no issues. Mr. Gupta, if you just rejoin us.
We'd wait for 5
Until
minutes.
then, I would like to, due to some medical inconveniences, CA Ronak Agarwal has not been able to be present for our conference. So I would like to request Advocate Nivedita Pathak from the Strategic Alliance team to kindly post a message from Ms. Ronak Agarwal for all our attendees and fellow guest speakers. Thank you. So that is Ronak's message for all of us. Yeah, Mr. Gupta. So we just...
Can you Hello?
Yeah, you may resume, Mr. Gupta.
Sir, you are audible.
Okay, fine. Actually, I was on the point, in case the eligible startup makes any capital gain, then that capital gain is also exempt by fulfilling certain condition. So that advantage is also there in case of a taxation with regard to startups. Further, with regard to GST, the GST returns have to be filed on monthly or quarterly basis. Some certain annual compliances are there, like for filing of Form 9 and Form 9C in case of a startup has exceeded a certain quantum of turnover during the financial year. Then moving on to labor law based compliances, a startup might be required to comply with Employee State Insurance, Employees Provident Fund Schemes, Maternity Benefit Act, Industrial Dispute Act, and Trade Union Act. Mind you, at this point of time, once you're registered with the government as a startup, on self-declaration basis, you are given exemption from compliance with from not from compliance but from any investigation or any visit or inspection from the labor department. In case of an industrial dispute act, the trade unit act, building and other construction worker act, ESI act, payment of gratuity, provident fund act. So there are 8 and 9 acts for which you are given an exemption. There will be no inspection of your unit, and for next year or year thereafter, on self-declaration basis, you can get the similar kind of relaxation. So from government side, there will be less and less intervention with regard to startup is concerned. Okay, so if you want to conclude, so I would say legal requirement is very crucial for any organization. Compliance with the relevant law where the startup is doing business is important. For successful setup,
లేదమ్మా ఇంకా అవుతుంది అలాగే
Sir, you are not audible.
am I audible now?
Yeah, sir, audible.
Okay, so I was saying I've concluded my presentation. So in case you want to ask any question, I would be more than happy to take any question with respect to my presentation.
Yeah, Mr. Gupta. So as you addressed, unicorn startups are actually, like recognized as with the term unicorn at a global scale. So in the Indian perspective, in the perspective of Indian compliance laws, once any startup like exceeds the required or the mentioned turnover rates, what would be the like compliances to be followed thereafter?
Okay, so see what I have discussed or my previous speaker had discussed. So these were the additional benefits which were given by any government or for that matter government of India to the startup to enable the startup atmosphere in India. So once your threshold limit is exceeded, there will be no penalty on you, but whatever the supplements were being given to you by the government, they will be taken away. So you will be at par with any other company. So you will have to compete on your own. So like a kid is there in a house, before the kid starts walking or even starts learning how to walk or maybe start learning how to bicycle, you give that kid extra support. So once you think that kid is stable or that business is stable, that business can take care of its own on a self-reliant basis. So you have to like take away those whatever crutches you have given to that business. So that business will have to run on its own. So I think that there is no negativity or there is no negative impact of removing those benefits given to the business. But I think business will be self-reliant once you achieve 100 crore turnover. Government in its own wisdom has thought about once a business achieves a turnover of 100 crores, it can be self-reliant. So that is how it is.
Okay. Thank you for the answer, Mr. Gupta. Actually, your speech was really amazing. Ms. Damini, actually, I have just one question for you. Their knowledge as a company secretary. In general, how many board meetings does a private limited company has to like do in the initial year of incorporation, the very first year for startups?
For startups, it is 2 board meetings. Actually, for a private limited company or for any kind of company, the rule is to have 4 board meetings. But the startup has been given an exemption under the legal perspective. If you see that it has been given an exemption under the Companies Act 2013, and now the private limited company, which is a startup, has to have 2 board meetings in a financial year.
Okay, so the resolutions taken in such board meetings have to be drafted and submitted to the management, or this company secretary is keep it separately?
Company is going to appoint a CS, otherwise they can just give away with that compliance, because it is not a mandatory compliance under the Companies Act, in the legal perspective.
Okay. And another question. Proprietorships, as we know them as of current, do proprietorships have the scope of development in the startups industry?
No. If you see, they have, but they do not have the direct reach to become a startup. Because the startup definition to be recognized as a startup, we have already read that it is limited liability partnerships, a conventional form of partnership, or the private limited company. So if you are already established as a sole proprietorship, then you cannot have a direct jump to be recognized as a startup. You have to get yourself incorporated into a private limited company or any of the other organizations and then go through that route. So there is no direct jump, but that does not mean that the innovative idea that a sole proprietor has made or invented cannot be, brought in the market, cannot be manifested in the startup organization. They can, but they have to change their roots. They have to change the form of organization to reach there.
Okay. Just last question, in case we are running a bit short of time.
Sure.
Okay. I would like to request Ms. Vaishali Shri to post the certificate link in the chat box for all our attendees to ensure that they fill it up by the time we end. Thank you. So, Ms. Anushka, the last question is like, as you said, proprietorships actually find it difficult in today's world because when you have founders basically started at proprietorship because they are not much experienced with entrepreneurship definitely. So once they start up as proprietorship, they do have a lot of issues in fundraising. The reason for that, exactly.
Can you just repeat the last line? It was not audible to me.
Founders do not start straightforward as a private limited company. They do start as a proprietorship instead, prefer that way. So such proprietorships do have a very dangerous issue of not finding enough investors or not being able to collect appropriate funds. So why is that so?
So then there are two routes that they can go through is there is a concept of one-person company that has been introduced in the Companies Act. So if you are a sole proprietorship and you don't want to get recognized as a startup in the very first year of establishment, get yourself registered as a one-person company where you are the single owner, where you are the director, and also you are getting so many benefits to be in a company. The limited liability and all the legalities are being complied with, which is not there in the sole proprietorship. But then yes, if you are going to incorporate as an OPC, the financial compliances as well as the legal compliances will have a little more weightage. So that is one route, and then later on when you want to get recognized as a startup, you can convert your OPC into private limited company and get that jump into the recognition of startup. And the second is you're not ready for a sole proprietorship, you're not ready for a company, but you're ready for a sole proprietorship. So why not to have a partnership firm? You can have your family member as a partner. The partnership firm has to be with two persons. So if you can have it with your family member, you will be a partner, and the partnership firm is getting a recognition as a startup, if you see the definition. So that is the another jump, and here you don't have to also bear the legal compliances that are given in the Companies Act and many more. The audit is also not necessary if you see the financial sector. So I think going through the partnership firm route is a much better option if you are planning to have a sole proprietorship.
Thank you for your amazing response.
Thank you so much, and thank you to the audience for a patient hearing, and extremely sorry for the network disturbance.
No, that's actually normal nowadays. That's it. Now I would like to thank all our guest speakers as well as all of our audience for patiently bearing through us for this journey of 3 days. We would come again next month with another conference 0.8 on emerging tax issues in incorporation of startups, as it's also a very budding issue for entrepreneurs. Until then, stay chill, enjoy your day, and fill up the certificates link because my team is not going to issue certificates if you are not actually filling it. So thank you everyone. Have a nice day.
One more thing, happy Holi.
Okay. Thank you.
Yeah, thank you so much.